Hi, I'm Kent Berk. I'm an attorney at the Scottsdale, Arizona law firm of Berk Law Group, where we handle probate, trust, estate, and other types of matters. I want to explain today what happened in the case of the Shaheen Trust. This is a case involving a no contest clause. A no contest clause is a provision that's included in a will or a trust, and typically they provide that if any beneficiary challenges the validity of the will or the trust, then they're disinherited and they get nothing under the will or trust. By statute in Arizona, no contest clauses are not enforceable in a will if the person had probable cause for filing the contest at the time that they filed it. And probable cause is the sufficient evidence that would cause a reasonable person to believe that they have a substantial likelihood of succeeding on the validity of the claims. And so if there's a challenge to the validity of a will by statute, even if the person loses, as long as they had probable cause, they had a substantial basis to believe that they would succeed based on the evidence at the time, then they're not disinherited. But if they file a contest in violation of the no contest clause without probable cause, then they're disinherited. So the question in the Shaheen Trust case was whether a no contest clause in a trust is evaluated according to the same standards as a no contest clause in a will. And the court found that the same principles apply in a will or trust contest, so that if a person did not have probable cause, then they can be disinherited in a trust contest case, just like in a will. The second question was, in that particular case, the beneficiaries filed like 9 separate claims affecting the trust or involving the trust, and the court found that the determination of probable cause must be met on each separate claim that was brought, and that the determination of probable cause is based upon the evidence that the attacking party, the challenger or contestant, had at the time that they filed the challenge. And in that particular case, the challengers, the contestants, filed 9 separate claims, one of which they claimed that the trustee was supposed to make distributions on a different periodic basis than what she was, as a result of which the trustee had engaged in misconduct. And the court found there was no basis for that challenge. The trust didn't require the distributions on the basis that the contestants were claiming, and as a result, that 1 out of 9 claims violated the no contest clause. They did not have probable cause for that claim, therefore they were disinherited from any interest in the trust. Now you might wonder, why have a no contest clause and why do courts enforce them? So a no contest clause obviously is to avoid costly litigation and allow the will or trust to be administered according to the wishes of the person who adopted the governing instrument. But of course, the ultimate purpose of probate law is to ascertain and give full force and effect to the person's wishes, so that if, for example, the person was unduly influenced or lacked testamentary capacity, then the courts don't want to enforce a will or a trust that's truly invalid, even if there is a no contest clause. Therefore, to balance those interests, the courts will allow a contest to go forward, even though it might violate a no contest clause. So long as the person had probable cause, they won't be disinherited. So if you have any questions regarding no contest clauses or will or trust contests or other types of disputes here in Arizona, please don't hesitate to give us a call.